Joseph Matal has joined us from all the way from Washington, D.C. to come and hear and talk and speak with inventors and talk about some of the things that's happening in the inventor field, some of the concerns that we have about the way the patent laws have changed over time, and some of the things that we see going forward. I know there's been some legislation that's been pushed by some organizations that we feel is a little bit more detrimental to the abilities and for individual inventors to be able to pursue developing and bringing products to market. And so that's something that we're all, feel near and dear to our hearts. And it's really heartbreaking when somebody spends their time and effort and bringing something forward and spend all the money on the patent and doing all the marketing and everything else to find out that their patent has been voided. And so that's one of the things that's really kind of put a lot of us on edge. And so that's one of the things that we wanted to address tonight. Did you have any opening comments that you wanted to make, or did you have any? I know we invited you here to hear from us, but we'd also like to hear from you. And
Sure.
If you could tell us some of the things that you see as being positive aspects of the changes in the American Invents Act over the way it used to be. I know there are a lot of us that appreciated the first inventor rather than the first to file. And that's been an issue that a lot of us have been a little bit concerned about, because naturally it makes us a little bit more close. I don't want to say paranoid, but paranoid about keeping our inventions concealed and quiet and not shown in front of anybody that might come along and steal it, claim to be an inventor, and go and file in front of us. So that was one of the things. I know it was largely done to help bring the United States in sync with the rest of the world, but I think from our aspect, why didn't the rest of the world catch up with us?
Yeah.
But so, Joseph, you want to?
Sure. Should I just come up?
Yes, please. And I have a chair up here if you'd like to relax.
No, I'll just come.
Thanks for doing it.
Happy to be here. I'm Joe Matal. I'm the acting director of the USPTO. Have been since early June, and probably will be close to the end of this year at least. Just a bit of my background. So I originally from California. I worked on Capitol Hill, and I was one of the people heavily involved in the American Invents Act. That law changed quite a lot over its 5 years on Capitol Hill, and I was pretty heavily involved in that process. Wayne mentioned the issue of first to file. I found this interesting. I spent last week in Geneva, Switzerland, of all places. The World Intellectual Property Organization held its General Assemblies. I've never been to Switzerland before, and basically every country sends out the head of their IP office, and it's literally like the UN. Like there's this huge room, and everyone has a tag of their country that's in French, and it gives these little speeches. And most of these countries aren't doing a heck of a lot with patenting, frankly. But then you have all these side meetings with different countries, and the big issue with that's always kind of percolating and has been for probably decades now is harmonization. How do we bring our laws into harmony? And it would be ideal if you had a good patent law and it was the same everywhere. So if your invention is patentable in the U.S., it's virtually automatic everywhere else. That they're applying the same standards. The problem is different countries have different standards, and Europe, and in particular Germany, doesn't have any kind of a grace period, and that's been a real sticking point for the U.S. The U.S. isn't about to give up its grace period, don't worry. But one thing that came through in the repeated discussions about harmonization that I told folks is, the U.S. isn't going to harmonize just for the sake of harmonization. I don't see the U.S. ever saying, well, this rule here that Europe has is really bad policy, but just so we're all, but if they take this other thing of ours, then just so we have everything the same, we'll take that bad rule. To the extent there's going to be harmonization realistically, it just it has to make sense as policy. I has to be good policy. For that reason, for example, I don't see the U.S. ever giving up the grace period. You know, the grace period is something that protects the little guy, and you know, it's the little guy who often just isn't even thinking about patenting in the first place and talks to folks, or you know, gives presentations that put the invention in the public domain. We actually used to, in the United States, we used to have a 2-year grace period. It used to be you could make a public disclosure and still patent within 2 years. Does anyone know when that law was changed? 1938. The 30s, kind of early 40s were a low point in public respect for the patent system, and they made some anti-patent changes then. That's the, so I was there on the Hill when the U.S. also decided to make the change to first to file. And I know it's controversial. I hear both sides of this issue, but the debate that went through Congress, and members really do think about this. It's easy to get kind of cynical about Washington from the outside, and it's all about money. But in the end, like you do have to, these members aren't getting money for their personal accounts. It's just for their campaign accounts. And I'll tell you, the senators and congressmen on both parties, they generally like America and are public spirited and want to see the country become a better place. And there's a lot of bad things going on, and people doing stuff for the wrong reasons. But overall, like if you have a compelling story to tell those guys, they'll listen. I mean, they overall the members do want to do what's right for the country, and the first to file debate kind of evolved the same way. There are arguments for first to invent, that it's simpler to just keep things in your notebooks, but the argument that was compelling on the other side was it's just so expensive to litigate over who has priority. An interference costs $500,000 that now the right becomes kind of illusory. If it's that expensive to rely on that type of priority. Also, one of the advantages of first to file was it creates more transparency for everyone else. Under first to invent, you don't know what a patent's priority date is until it's litigated. So if you have competing patents over the same thing, you don't know who's going to have priority, who's going to claim an earlier date. You also don't know what's prior art against it. It makes it a lot simpler for the rest of the world to have that clear priority date that's based on the filing date. So that's how it's characterized now as harmonization, like, oh, we did this just because that's what the Germans and Japanese do. But there really was a public debate about these issues, and the members really were sold in the end that this is just a more efficient system, that it's it's cheaper, and ultimately for the the system works better if people file earlier, if they at least file that provisional application. There's no ambiguity about what your priority date is then, and who has priority. And that's kind of the pitch I'd like to make to you all, is I'd like to encourage you to stay engaged in this debate. Wayne's right that there's legislation that's been considered on Capitol Hill the last couple of Congresses that would have been pretty hard on small inventors. Would have made it a lot harder for you to enforce your patents, and if you can't enforce them, they're not worth anything at all. And I think members would be interested in the stories you have to tell about how the patent system is, how it works for you, because one of the other things about the patent system is it really is designed to work for the little guy. It's great that these big companies can get all these big patents, but real innovation often comes from the small startup, people who aren't kind of inhibited by some corporate culture and are able to act on ideas that you wouldn't be able to sell to a corporate board. And if you look at the just to give you an example, the chief judge of our Patent Trial and Appeal Board, and I know the PTAB is controversial, but our chief judge came from Medtronic, and he likes to brag about how he did billion-dollar patent licensing deals while he was there. And one of the things I've heard him say in meetings is that when he was there, they only spent a fraction of their money, something like a quarter, on buying smaller companies, and 3/4 on just their own internal research and development. He said over the years he found that the truly innovative stuff they acquired, the really revolutionary products that really brought in the money too, tended to disproportionately be from those purchases of smaller companies rather than the stuff they did in-house. There's just something about the culture of big companies where they don't encourage these revolutionary ideas that really are the groundbreaking inventions. And that's just a story that needs to get out there more, and that people need to appreciate more about the system. The health of the patent system, and that's why I'm out here. The health of the patent system depends on how it affects you all and whether it functions for you, the small inventors and the startups. Earlier today, we met with the National Academy of Inventors housed at the University of South Florida, and they're more kind of university-based researchers who are getting into small businesses, and they have these little incubation labs, and some of it is just undergraduate students who don't really know that much yet, but who are getting started with their little things. But some of this stuff is developed into pioneering inventions in biotechnology and other fields, and they have the same story. They're the ones who are really on the cutting edge of a lot of science, and although they have this comfortable university to rely on, they face a lot of the same economic pressures that any small inventor would do. And again, if I have one message for you, it's to stay engaged with those of us in Washington and with public policy. Don't get cynical about the system. It's a democracy. Anyone can win and run, and we're always Washington D.C. in the nearly 2 decades I've been there now. It's constantly getting refreshed with new people coming from outside and who have a fresh perspective. And if your story is pitched the right way about, hey, look, we're kind of the lifeblood of innovation in this country. Another story I like to tell about why the patent system matters is innovation is really, over the long term, what distinguishes the countries that rise to the top and stay on top from the countries that decline. Look at a lot of the countries that were the top dogs in the 19th century in Europe, for example. A lot of those, let's admit it, are second-rate powers now. And it's because they gave up on innovation. They stopped being the places where things happened first. And the patent system, the entrepreneurs and the guys willing to pursue a bold idea are really key to keeping the whole country ahead over the long term. So anyway, I've just been talking nonstop. I mainly came to hear from you. Wayne, can I open it up to the audience?
Sure.
I actually have. There were some members and heads of other clubs around the country that actually Wayne got them to put forth some questions they had. I thought we'd start with that, and then we can open up to the floor here.
Sure. And I've got the list here. I'll let you go ahead and deliver it.
I should caveat too, I'm just the acting director. There's this development who's been nominated. It'll probably be installed towards the end of the year, so I can't get out ahead of him on any policy thing.
Well, as long as you didn't get your acting job through Harvey Weinstein, you'll be okay.
Fortunately, we weren't affected by that.
But the first is from Steve Lyon of the Minnesota Inventors Network, or the Inventors Network of Minnesota, which is, I think, the oldest inventors group in that area of the country. And his question is, can the USPTO institute a standing requirement before a challenger can file a petition? We're talking about like a PTAB type petition. That's the first part. The second part is, can the USPTO raise the standard of proof needed to be met to invalidate a claim?
So on the first one, in limited circumstances, I think we'd have the discretion to do that. Sections 314.
For standing?
Okay. And 325D, and the courts and commentators have generally acknowledged we have just a lot of discretion over whether to institute.
By the way, guys, what we're talking about here is if someone wants to invalidate your patent, right? Standing means they have like a legitimate need to invalidate it. Maybe they have a competing product, they claim your patent shouldn't be valid anyway, and therefore they should be able to try to invalidate it. Or they have to have some legitimate reason for wanting to invalidate it, as opposed to like the guy that did the hedge fund guy that was just trying to short stocks. Right, I'm sorry, go ahead.
Yeah, my view, so I used to work in the solicitor shop at PTO, so I spent a lot of time litigating over these questions of the extent of our authority. And my opinion as a lawyer is we could impose a limited requirement, saying certain classes of inventions, for example, aren't going to be eligible until there's litigation or some kind of more pressing need. I think we could do that. The second question, the burden of proof is dictated by the statute. That's in section 316E. and it says preponderance of the evidence, and that was carried over from the system that inter-parties review replaced, the inter-parties re-exams, which also used a preponderance standard. This was actually an issue that was debated somewhat back and forth while the AIA was moving, and there's an earlier version of the AIA actually that I worked on for Senator Vitale that used the clear and convincing standard to align it more with district courts. Some of the pushback on that came from the PTO itself, which took the view that, we're the expert agency, we understand the technology, so the standard of proof shouldn't turn on that. Either the prior art reads on it or it doesn't. Even within PTO, you get debate about how much, would a different standard of proof make a difference. I've talked to judges that take different views on it, but since it's dictated by statute, we couldn't alter it directly. There are things, though, that the board is doing now, and this is without regard to, the Patent Trial and Appeal Board is a common law process. They decide, one case after another, and their precedents build on each other. It's a lot like the Article III courts, and their jurisprudence kind of evolves on its own without any direction from me or my predecessor. They've increasingly adopted this approach that if the same prior art or something that is effectively the same was previously presented to the office, and that includes an examination, then we're not going to institute unless it was clear, that the examiner was wrong, unless the examiner's determination was unreasonable. So to the extent, at least for the prior
And that's a
art,
fairly new development, right?
yeah, it started to, a lot of the history of PTAB proceedings is, I remember when I was there when the board was inaugurated in 2012. I had just started working at PTO, about a month earlier, and I went to the initial, inaugural event to start the PTAB. And the thought in everyone's mind was, is this thing going to work? Because the history of, PTAB and the new inter-parties review proceedings, the history of that is all the mess that inter-parties re-exam could become before then. So in '99, Congress created inter-parties re-exam, and the idea was you need a re-exam where that third party is still allowed to participate, keep it adversarial, keep another point of view in front of the examiner. And by about 07, 08, it was clear those proceedings were becoming a mess. The examinational model just doesn't work when you have two parties fighting with each other. The examiner's always kind of responding to one side and then to the other. And examiners aren't lawyers, and they really don't know how to manage lawyers and their tactics. So what we were finding is these things were just dragging on forever, building up this huge paper record without really getting to the substance of the issues. I've actually defended some of these board decisions in the old inter-parties re-exams on appeal when I was in the solicitor's office, because when one of the parties drops out, when the original requester drops out, we step in just to defend the board's decision, and they're just a mess. I mean, take the paperwork that you get in an examination and just put it on steroids. You get the examiner's final rejection, then his action closing prosecution, then his right of appeal notice, and the brief. And the examiner is not only responding to what the patent owner said, but to everything that the third party keeps adding in, and it creates this huge mass of paper. And these cases were are dragging on for 5-6 years before the examiner. And the way the way they were structured on that examinational model, either party, if they want to, can delay the proceeding, and that just doesn't serve anyone's interests. It doesn't become a real quality check of validity, and a lot of district courts varied on this, but a lot of district courts would stale proceedings in an infringement trial if there was an inter-parties re-exam pending. A lot of courts aren't that wild about hearing these complicated patents cases, and if this inter-parties re-exam is pending, that's an excuse to freeze the district court case. And when that delay begins to look like 5-6 years, and under that old system too, you had to appeal to the board after you were done with the examiner. So that was a lot of the reforms in the AIA around these proceedings were designed to get out of that model. We just need something that moves more expeditiously so it doesn't tie up infringement litigation.
I got it. Well, this next question kind of relates to that as well, so it's a good second question on it. This is from Warren Tuttle, who's the head of the United Inventors Association, which is a national group. Does the PTAB operate under the exact same guidelines as USPTO examiners do when post-interpreting previously approved utility patent claims? And if so, why do an unbelievable 88% of all approved patents the PTAB reviews result in at least one claim reversed?
Well, the answer is we try to apply the same standards. People think, there's this impression out there that when the PTO issues this guidance, it's trying to shape the law. You know, we don't have time to try to shape the law, and the courts wouldn't listen to us anyway. We're just trying to keep up with the latest Federal Circuit, permutations in their Law of 101, which is, just keeping up with those decisions is quite a struggle for us. And the board is applying the same law. You get, trends in different directions in the two bodies, but they're both reviewable ultimately by the same board. So that keeps us disciplined. I forget what was the kind of second part of the question.
So, if so, in other words, if they're using the exact same guideline.
Why is there such a high invalidation rate?
88%.
Well, so the invalidation rate is high once you get to that final written decision.
Right.
But, so part of the problems with the old inter-partes re-exams as well is, does anyone know what the institution rate for inter-partes re-exams was? 95%. So basically, any competent lawyer could put together a petition that could pull a patent into an inter-partes re-exam. So part of the goal with the AIA was to create a high threshold and other disincentives to even bringing the case unless you had a strong case. So the old inter-partes re-exam, the test was substantial new question of patentability. You basically had to find some prior art that was arguably relevant and hadn't been considered. The AIA bumped that up to reasonable likelihood of invalidity. This is a change that the board actually lobbied for the hardest. They just didn't want to bring in marginal cases. So at the outset, you're trying to weed out, the weak cases, and about a third of cases are denied institution now, as opposed to, just 3 or 4 or 5% under the old system. So, and then once you get to trial, about 2/3 of the cases have all the claims wiped out, and another 20% wipe out some claims. But that's after you go through this institution phase, where we really tried to discourage people from even starting the proceeding unless they had a strong case from the outset. From data we've seen that have been collected by Lex Machina, which tried to look at all district court cases in the country, they've run data the last 5 years where they look at, of all the patents that have been litigated in district court infringement cases, how many resulted in PTAB proceeding? I think the last 3 years it's been about 15% of cases. So you have about 15%, about 15% of the time that there's a district court litigation, you get an IPR filing. About 15% of those settle pre-institution, and then again, about only 2/3 of those are granted on the merits. So that gets you down to about 8 or 9% of district court litigations result in an instituted inter partes review. So that's, again, it has to be right on the merits. It ultimately comes down to, is the board making the right decision on the technology? But that's sort of more what we hope for, that where you can't just start this proceeding in every case. We would hope that the vast bulk of our patents are perfectly valid, claim a patentable invention, and shouldn't be involved in one of these proceedings.
I got you.
Go ahead.
Yeah. Okay. Was that all on that?
I also wanted to say, we've studied, in the cases where they get to trial and claims are invalidated, what went wrong? What did we do wrong, right? We're the ones who examined it. Why did we grant this patent if the board's later saying it's invalid? And overwhelmingly, we find they're invalidated because of prior art that just wasn't before the examiner. Someone who's been sued for infringement just does a much more rigorous search than our examiners do. Our examiners are reviewing about 600,000 patent filings a year, and we have a pretty big core, but they only have a limited amount of time to search, and in a lot of these cases, they just haven't found the relevant prior art. So we looked at it, and often it's stuff that wouldn't have been staring the examiner in the nose. He would have had to do quite a bit more digging to find the prior art that was considered in the PTAB trial. So. Sometimes examiners make mistakes, or they should have found it, but overwhelmingly we find in these cases that the board is considering art that just wasn't even in front of the examiner.
I got you. So this is from Gary Steckling. He is the head of the Inventors Association of South Central Kansas. Is there any way to accelerate and simplify the litigation process so that infringement cases can be settled in 6 months instead of 6 years, and reinstating injunctive relief while the process is underway? Injunctive relief would be where, while you're suing someone for infringement, they are stopped from producing your patented item.
File in the Eastern District of Virginia. They have a rocket docket there and reach the merits a lot more quickly. Different district courts around the country are quite a bit different in terms of the pace at which they decide cases. In terms of injunctions, the Supreme Court issued its judgment in eBay about 10 years ago now, and a surprising amount of patent policy in this country. This is another thing that came up when I was talking with all these foreign countries' patent offices in Geneva. They were surprised at how much of our policy is set by the U.S. Supreme Court. These countries don't have as aggressive a high tribunal that's deciding all these issues, and our Supreme Court obviously aren't patents experts, so sometimes you get they're generalists, and the other thing is, I followed the whole I don't know if any of you do life sciences, but the whole Sequenom v. Arioso litigation over it was an effort to pare back some of the Supreme Court's the holes it created in eligibility in the life sciences for medical diagnostic techniques. And all these people had their hopes pinned on, we're going to file this cert petition and get the Supreme Court to fix what it did, in Mayo and Myriad. And I remember watching it from a distance thinking, your first error is assuming the Supreme Court ever fixes its mistakes. Once they rule something, you're done. I mean, that's why it's important to file amicus briefs in these cases and get the arguments done, get everything relevant before the court the first time, because the Supreme Court really rarely reverses or even pares back one of its own cases. Once they rule something, one way you're done.
Yeah.
The only way to change, so I don't see the Supreme Court ever substantially modifying eBay. You'd have to go through Congress for that, and that'd be a heavy lift, because there's a lot of people who are sued for infringement who like eBay. They don't want that injunction levied against them. So.
I got you. So this one is from Adrian Pelkus, who's the head of the San Diego Inventors Forum, and I think I'd like Paul to introduce.
Yeah. So this one requires a little background. So it's a real simple question, but the Constitution defines a patent as nothing but an exclusive right. I think the very first Supreme Court decision on patents was in 1813, or right around there, and Judge Warren, the very first Chief Justice, wrote it, and he said that you have a property right in the idea, and the patent simply gives you a vehicle to enforce that property right. Every Supreme Court decision, all the way up until Eye for Eye versus Microsoft, has declared a patent a property right. Black letter law, I don't know, is this 282? I can't remember what section it is, says that a patent should have all the attributes of a property. It's black letter law, it's Supreme Court precedent, and if you look at an exclusive right, I mean, that's the very essence of a property right. Your predecessor, in a response to Oil States is a case where they're asking the Supreme Court to decide essentially the constitutionality of the PTAB to begin with. Can a property right be extinguished in an Article III court without due process and without a jury? So in the brief that was filed by the Trump administration under your predecessor, it said that a patent was a public right, not a property right. So my question to you is, since you're interim and your predecessor is gone, and there isn't any, we'll have briefs filed again on Oil States, I think October 30th.
I think the government must have already filed this brief.
Yeah, are you sticking to that position? Do you believe that a patent is a public right, or is it a property right? That's a question from Adrian Pelkus at the San Jose Inventors Council.
San Diego.
Yeah,
San Diego.
Some people might debate this, but I think it's pretty clear that a patent is private property. The fact that it's authorized by federal law doesn't preclude it from being property that's protected from taking by the government under the Fifth Amendment. The question, though, of whether something's private property or not, the question of whether it can be adjudicated in the federal administrative proceeding is a different question. In defense of my predecessor and all past PTO directors, we don't, especially on these constitutional questions that have broader implications for the federal government, they don't always file, the brief exactly the way we would want it. Anyone who's familiar with the history of the Myriad case would know that sometimes PTO is entirely ignored. But on this issue, this is one where the Justice Department has a pretty fixed position, because they're looking at it from the perspective of, gee, if these PTAB trials, are unconstitutional, pretty big swath of the federal government does is also unconstitutional. And, you know, the government's, the Justice Department's role is to defend federal law and to defend the operations of the federal government. You know, frankly, under Obama, there were cases where they declined to defend federal laws that they didn't like, and that was pretty controversial. The accepted, you know, mainstream position is DOJ is the lawyer, not just for any particular party in power, but the lawyer that defends the federal government. You know, over the last 100 years, a pretty, you know, a large set of administrative proceedings have grown up that adjudicate all kinds of questions in administrative tribunals. And, you know, maybe that was the wrong path to go down 100 years ago or not, but we've gone down that path. And the government's, you know, Justice Department is going to defend, you know, those institutions and those precedents. You know, I also, coincidentally, I happen to be the associate solicitor who got assigned this case the first time it came up, and I looked into this law of what's, you know, basically what can you adjudicate before an administrative agency and what has to be litigated in court. And you know, the test is pretty broad. I mean, I think the patent office, you know, we'll see what the Supreme Court decides, but the test is pretty well set. And one of the things they look to is it a case where, you know, regardless of whether it's private property or not, is it a case where the right arises under federal law? The thinking is partly, well, if the federal government created the right, it can also determine the circumstances in which it's adjudicated. And then the Supreme Court also seems to, they don't put it this way, but they seem to have kind of taken this practical perspective of, is this a case where the administrative agency has some kind of expertise that they're applying, and we think they do a better job. And I'd like to think our administrative patent judges, you know, who all have technical backgrounds, do have expertise that makes them, you know, particularly adept at adjudicating these cases. Not only do they understand, you know, and when when the board assigns panels, for example, they don't just say like, oh, you have a, you know, double E degree or a bio degree, you can sit on any case. They try to match the judges' backgrounds to the technology that's going to come up in that case. And we even have procedures where if a judge, like once he gets into a case and was assigned, if he or she feels out of their depths, they can just basically raise their hand and say, I don't really understand this stuff, take me off this case, and put someone else on it. I think we sometimes have to make exceptions because you get a surge of cases in one type of technology, electrical, over the last years, and you don't have quite enough of those judges, but they generally try to do that. And the other thing is our APJs, you know, they know patent law cold, they know the case law, you know, quite well. We've had you know, with the size of the board, I think when the AI was enacted, the board was about 80, 90 judges, and it's grown to 270. And we've been able to hire some really high-quality people. Part of that is just, to our benefit, private law practice has become pretty miserable in a lot of these big firms. So we get these 6th, 7th year associates who are just burned out and have been working these long hours and are happy to come over and be a judge for us. And a lot of our judges have not just technical degrees, but PhDs in various fields. Our current chief judge has a PhD in organometallic chemistry, which I've never heard of before. Not even sure that PhD is legal in all states. You know, they're an impressive bunch. We've been able to hire some good people who, you know the technology and know the law. Now the question of are rules and are they fair? You know, look, I've told people repeatedly, one of the things that also went into the AIA is we saw that, gee, these inter-partes re-exams really became a mess. You know, they really weren't functioning in any way that served anyone's interest, and none of this was foreseeable. So let's not lock the agency into one model. Let's give the agency authority to course correct. You know, give them authority to issue regs, and you know, if they see one thing isn't working, then you know, let's let them adjust it on their own without having to go back to Congress, because Congress just never gets around to fixing these things for them. And so, you know, people who are, you know, you get a lot of people now who are like, oh, PTAB trials, I love them. You know, I got sued and, you know, they wiped out this patent that I didn't like. And you can't change anything. The way it was implemented in 2012 is just the way it's meant to be. Like, that wasn't the intention at all. The intention was that PTO itself would periodically revisit these proceedings and make sure that they're functioning in a fair way, that they're really serving the, you know, the interest that the patent system is designed to serve. So frankly, it'd be surprising if we didn't, you know, after a period of a couple of years like we now have under our belts, revisit these proceedings and ask, are they fair? The other thing I've kind of noticed from my years of defending the PTO in court is it really does kind of begin and end with the board with a lot of these cases, because the judges on the federal circuit, a lot of them don't have any technical background at all, and especially for the really, some of the really complex inventions, the really cutting edge stuff, they don't know the technology. I get the sense they're kind of relying on the board to get that part of it right, and they're there to make sure the procedural rules are right and the board adequately explained its reasoning. But that real merits decision, for what I've seen, is really made with the board, which makes it incumbent on us at PTO to make sure the board's getting it right, that the procedures are fair, that all the right arguments are considered, et cetera. So I expect that to be a focus over the next couple of years. We have about 5 years under our belt now with these proceedings, and it's so, we have enough data, and have received enough commentary that it's a good time to look at, see how we could run these proceedings better.
Do you understand why it's important for people in this room to have an actual property right? I'll walk you through a quick scenario.
Well, if you didn't have a property right, the government could just pass a law saying your patent is invalid. And now if Congress passed that law, you could sue the federal government in court and get a taking. So they're not going to pass.
That is a problem, but the bigger problem is if you are an early stage investor, you're going to put in 50 grand into my company. All I have is this little piece of paper called a patent. And what it represents to you as an investor is a force field to me. Nobody can pierce it. That'll give me an opportunity to take your money, and I might be able to establish a toehold in the market to compete against the big companies that would steal it. That's the exclusive right. eBay's gone, companies pierce it all the time, and when they do, like my company, you get run out of business. And in most cases, because you're the investor, when the company goes out of business, you own the patent. That makes you a patent troll. And that property right transfer to you, if you don't have the same rights as I have, then it's not worth investing in me at the beginning. The attributes of a property right on a patent are what drives capital to small inventors so they can start the next industry. And by this whole PTAB thing, we're screwing it up, totally screwing it up. What used to be 84% of our venture capital invested in U.S. companies just 20 years ago is now over 50% in China. The last calendar year, 84% of the patent infringement cases in China were won by the plaintiff, and 1/3 of the plaintiffs were independent inventors. It's because the communist Chinese have a better property rights system than we do. And so that's a very, very important question from them. I'll
We
move
have
on
a
now.
301 investigation going on with China, so I'm kind of limited in how much I should talk about China, but I wouldn't move to China just yet. There's actually a ton of litigation going on in China, and plaintiffs do pretty well, but the damages are pretty small. And their authorities that handle these issues are also in charge of kind of national economic development. So one thing we wanted to study is, okay, but if you're an American in the Chinese courts, what are your odds of winning, especially on something important? Just forget about China though. Like whether they're doing good things or bad things to their system, what we need to focus on is our system and how well our system is working, and is our system serving inventors, and if not, what can we fix? What can we do to make it better? One of the positive developments from the inventor's perspective the last couple of years is the HALO decision, for example, which sort of loosened up the rules on trouble damages. And we still don't know exactly where that's going to go, but if you don't have eBay, eBay basically prevents you from getting an injunction unless you're commercializing the invention, unless you're trying to build a market, and even then it's pretty limited. So eBay really limited your leverage as an inventor holding a patent. But with HALO and a prospect of broader trouble damages, if you have that infringer who is pretty clear they knew about your patent, and there was no good argument that they weren't infringing it, and it was clearly a good patent, then you can hammer them with trouble damages. And that's kind of to me, the main purpose of trouble damages is to go after that guy who's copying, the guy who saw your invention get out there on the market, or learned of your patent after you tried to negotiate with them and then just stole it from you. That's really where ideally treble damages could be channeled towards. And I participated in kind of trying to craft the government's brief in that case, and we really tried to steer it towards, every time someone's caught copying, for example, there should pretty much be a presumption in favor of some kind of enhanced damages, because those are the people you really want to deter. That's the purpose of enhanced damages, to punish bad behavior. And so I'd mark that as a positive development. We're seeing more awards of treble damages these days in favor of inventors. And that's the kind of thing that could change that culture of negotiating. And I've talked to people who were lawyers for decades for big law firms and advised big companies. And I had one guy who's actually pretty famous, but I'm not going to name him, tell me that he's been in meetings where the corporate board is talking about, like, the sales guys say we're getting killed because of this other guy's product and it's eating up our market share. Can we design around it? No. They have this patent. Yeah, is the patent, can we invalidate it? No, it's like a pretty strong patent. Well, how about if we just flat out infringe it? And this guy told me he's been in conversations where it came down to, well, if we do that, we're going to get hit with treble damages. And that was the final thing that persuaded a big company to respect someone else's patent. Go ahead.
How do you get to that point of getting to treble damages?
It comes up in the infringement trial. Different judges handle it differently, but as you're pursuing your infringement trial, you say, not only is my patent valid and not only did this guy infringe it with his product, but he knew about my patent. He knew what he was doing. Often with copying, you can show, like, look, I talked to this guy, and then lo and behold, he comes out with the same product that's in my patent. Or, like, often people who copy, they copy everything, even the features that are incidental. You can often prove pretty clearly when someone's copying. And again, like, the HALO decision is still relatively new. We don't know where it's going to go, but that's one thing I'd offer as a positive development. If we can get a more robust case law, especially awarding treble damages against that guy who stole it, or who copied, that could, again, change the whole culture and make people more willing to respect patents.
I'm an independent inventor, and my background is that I, based on my new products, started 2 manufacturing companies that are still creating products, clean manufacturing jobs, exports, and all that kind of stuff. And I've just been concerned over the last decade or so that the level playing field is so important for independent inventors. And I think more and more people are understanding, like you said, that the breakthrough products are often from independent inventors. You can look at Apple, Microsoft, Google, on, and they develop into huge corporations, oftentimes tremendous for our country. But it seems like sometimes they get so big and they start throwing their weight around, and instead of, and balances it towards, even though independent inventors started, they're using their weight against independent inventors. So I'm concerned about that, particularly with PTAB and some other legislation that has come up. Just as an example, many independent inventors will spend thousands and thousands of dollars, mortgage their house, spend years on an invention in the thought that there's an 86% or 92% chance that it would be thrown out if it got the PTAB, is very demoralizing for anybody, and certainly for any investor. Just to put it in terms that might be more easy to understand, if you spend 3 or 5 or 8 years building a house and put a few $100,000 in it, and there was even a 25% chance it would be taken away from you, that would be something you wouldn't want to do. And we all have a choice of working on your products. At times is fun, but as you know, patenting and writing patents and prosecuting is not fun. We have a choice. We could be with family and friends and recreational activities. We have to have a pretty strong incentive to do things that have a potential of a long-term payoff in the future. So appreciate any efforts you can have in continuing to listening to some of the stories of independent inventors and problems they've had with the system the way it is currently. So, yeah, thanks so much for coming.
Yeah, I definitely agree. We could use as much certainty as possible in the system. The things we can do in Washington are just try to have clear, transparent, and fair rules for all of these proceedings. And there are definitely things we can do better. I mean, I've defended the government in a lot of these cases and felt like, okay, we can win this one, but did we really have to do the rule this way? You know, I'll acknowledge that there's room for improvement in the way we run some of our processes. Yes?
I have several patents that are in manufacturing, and I have never had a problem in the United States, but I constantly have a problem in Alibaba. Is there anything that the patent office can do to Alibaba? I mean, Google, Amazon's really responsive, eBay is really good, but Alibaba is a real serious issue for me worldwide. Like, it's seriously ruined probably 35% of my global market just from them. And I mean, when you say they copy, this guy copied my photos, my instructions, every single word I ever wrote, he's got on his website, and he's someplace in China, and my patent attorney is really good. She's taken quite a bit of action, but it's like weeds. It's like you beat them for 90 days, and then they come back, and you gotta just do battle again with them. Isn't there anything you guys can do?
So the Trump administration has launched what's called a 301 investigation. I think these are run by USTR, and it's basically when you're investigating a country for unfair trade practices, which in China's case heavily involve IP counterfeiting. Because that investigation is going on, they don't want the acting patent office head saying too much about China and these issues. But I know that we've said in the past in public testimony that about 87%, I think, of all counterfeits coming into the U.S. Come from China, just from that one country. You know, if China cleaned up its act, literally 87% of the counterfeiting problem would go away. And some of these countries, again, I don't want to name names, there is this institutionalized culture where it's just not shameful to rip off other people's IP. I just hope the administration comes up with remedies and ways to persuade these countries to follow the rules. When I was in Geneva, we discussed these same issues with some of our foreign counterparts, and the British told us that the problem with counterfeit goods coming in from China in particular has gotten so bad that a lot of it comes in by mail order now. People order a counterfeit good off a website and it comes in from mail. That the British had started to direct all mail from China to the town of Coventry. Which is kind of ironic. Coventry is where people were sent for exile in the English Civil War. Yeah, you're right, it's a problem. All I can tell you is the administration, this administration started this 301 investigation to look into China's practices because they've noticed the same thing you have. We at PTO don't play a direct role in enforcement. We kind of complain to the other agencies about bad things that we hear, or trade, patent laws in other countries that we think are unfair, that discriminate against the U.S. You're right. We're aware that it's a real problem. There's a real culture of that. There are laws governing when you can go after a website. So even if eBay is selling counterfeit goods, they have a certain amount of immunity if they supposedly didn't know about that. I'm not an expert on that. Frankly, at PTO, we're thrilled to see other parts of the administration that do have a role here taking these issues on, giving it a hard look.
So do you feel that the current administration is doing a better job when it comes to inventors' rights and the kind of the issues that we're talking about here than, say, the previous administration?
Yes. This administration is focused on economic growth, productivity growth, innovation. It's a real priority from them. It's a real change in attitude. I mean, just the fact that they've started these 301 investigations and are, going against counterfeiters and these, corrupt practices, it's a real focus. Our current Commerce Secretary, he's a businessman. He made his money bringing back steel mills and bringing them back to life. He's really focused on operations and how things work and what really moves the economy. He gets these issues and he gets, what moves the country ahead and, what's really important. So I have a lot of faith in this administration. I think there are people who are focused on the right issues and who are focused on, what really drives innovation and moves the country ahead.
And you're here.
I'm
That's a good sign.
Oh, Randy invited me. So,
You took them up on it.
Yeah, you don't have to burn patents to get me to come. I'm happy to come otherwise.
Not burning any.
Trying to discourage Randy from doing that. You guys are supposed to be pro-patent. Symbolism doesn't quite seem right when you're burning them. Yeah, talking to folks around PTO, no one could ever remember having had a protest at PTO for that event. So it created a little bit of a buzz around the agency. You know, someone noticed us for once.
Other than you having more money than the rest of the departments.
Yeah, and we want to keep it all.
Yes, exactly.
Instead of being diverted to other
Yes.
places, so, yes.
The biggest problem that we have is when somebody invents something and is trying to sell it. And that's pretty hard to do, and there's a few people on that call themselves brokers, but then when you contact them about trying to sell something, then what they want to do is help you in getting more patents and stuff that you don't even need, and charge you $6,000 or $8,000.
This has been a recurring problem with invention promoters who say, you know, hey, you know, I'll not only help you, you know, with the, you know, get your IP, but also like, you know, I have connections to manufacturers, I'll get your product out there. And these people don't know no one, and they've never gotten anything manufactured or commercialized. And it's a racket that's been going on for a while. The FTC's brought a couple of cases against these folks, and we're aware of it. At PTO, actually, we recently held a forum on the same problem going on in the trademark arena, and kind of false, people send out these documents to trademark owners. They scrape our databases for publicly available information about trademark owners, and they send this official-looking document from, like one I think was called the Patent and Trademark Agency. And you know, you get it, and like it's easy to see how people might think it's from the government. They say, oh, by the way, you owe us $1,100 to renew your registration or to get listed on this other registry. We actually recently agreed to detail 2 of our trademark examining attorneys to, I believe it was the Justice Department, to focus just on going after these people. The power we have directly at PTO is to bring Office of Enrollment and Discipline proceedings against these folks. I think we recently suspended a lawyer, a woman in Arkansas, who was working with one of these, you know, worldwide invention promotion companies, and you know, they bilk inventors with, you know, for thousands of dollars with all these promises. And when you look at their history, they've never commercialized anything, and they're just taking people's money. And what we can do is, you know, these people work with a real patent agent or a real patent lawyer who has a reg number, you know, with us, and we suspend that registration. So if a lawyer works with one of these crooked outfits, you know, we can cut off the right to practice and make them really think twice about, you know, who they get involved with.
Joe, we've seen recently groups like CEA and other groups come forward and put forward an image of patent trolls that are walking through and stamping on and just waiting for companies to file stuff. And can you talk a little bit about the issue of patent trolls and whether or not, you know, what they're complaining about is really what you're seeing at PTO?
Yeah, you know, one of the best definitions I ever heard of, practical definitions I heard of troll is anyone who's suing me is a troll. A lot of folks seem to look at it like, look, the way the patent system is fundamentally different from trademarks. There's no requirement that you know, manufacture the claimed invention in order to enforce your patent rights. And a lot of famous inventors through history focus their energies on R&D and inventing and patenting. You know, Thomas Edison, you know, is often cited as an example, and that's just how the patent system works. You're allowed to do it as long as your patent is valid and your claims are infringed. You're allowed to enforce it. Oh, thank you. That's just how the system works. I mean, you do get people out there who file lawsuits without any expectation of ever going to trial on the merits, and they try to settle just for a fraction of the cost of litigation. That's a practice we obviously frown on. You shouldn't sue someone for infringement unless you have a reasonable good faith belief that they really do infringe your patent. Yeah, you know, a lot of terms get tossed around there. You know, actually one of the best things I saw about the term troll was something that was in an FTC report of all things we often don't see eye to eye with the FTC on. IP issues, but they said, we don't use the term troll because you're prejudging things if you start out just by labeling people.
Right.
Like, look, if the person has a patent and it's valid and infringed, they're allowed to enforce it, and that's how the US IP system works, and that's how it's worked for quite a long time, quite successfully.
Yeah, I'm just, a little bit concerned that there are groups out there that are making a big issue about something that,
Everyone has their
Yep.
interests, and, I've been around these patent policy debates in DC for, going on a decade now, and everyone fights for what's, in their interests. The big tech companies have their perspective, and they're primarily defendants, that's how they see things, it's all trolls out there. Pharma has its own worldview and occasionally asks for things they ought not have, but that's why, frankly, I'd like to see you guys more part of this process and more of a voice. And especially in Congress, they ought to be sensitive to legislation that would injure the interests of small inventors, because again, I think they're really the lifeblood of the real path-breaking innovations. And I expect that this administration will be much more sensitive to those concerns. Again, if you're focused on long-term economic growth and productivity growth, you got to focus on innovation and especially the ability of small entities to rise up and topple the lazy incumbents who are relying just on market power. That's what we all look, I'm only in this job for a couple of years, at best, and in a role at PTO, I and Mr. Yanka, we care about the long-term future of this country, and we want to see it succeed, and we want America to stay number one, and a huge part of that is preserving this culture and strengthening this culture of innovation. Paul, you had a question?
I have one comment. You mentioned that when you sue somebody and settle for a small amount to avoid litigation, you never really intend to go to litigation. When you settle, you're settling for the actual amount of the license that should be, because not all patents are multi-million-dollar licenses. Many patents are $30,000 to $50,000 licenses. So both sides agree to settle, and they settle at what the license should be. So to discount the entire practice, I think, screws over small inventors. So I just wanted to bring that up.
There are definitely cases where a small settlement still reflects the real value for a minor invention. It's really hard to it's really hard to judge any individual case without just getting into the details and the merits. What's alleged to be infringed. What's the scope of the claims, and what's the strength of the underlying patent. So, any kind of broad characterization is really dangerous. Every one of these cases is its own little story.
With that said, do you think that patents should have sections, like technology section, pharma section, toy section, retail consumer goods section? It's been so long since we've had any kind of reform to throw patents into a broad spectrum, into like a barrel, and then say, well, pharma has its issues, and then you have to find a detailed case of that. If you deal with toys, you have an 18-month life cycle. I grossed $60 million in less than 5 years with a couple patents that I had, and I wrote a book on the subject of patents. It can get very ugly very quickly, and especially if you're a small fish, and you have Matal and Hasbro that have all the lawyers in the world. They can hire Greenbrier, they can hire any lawyer they'd like to hire, and they can literally budget their toy 3%, 7% just to fight you, and eventually you'll give up. So I think we're here today, I've been asked to come here for reform, right? I mean, you want to take a system and look at it and say, it's 2017, why can't we stop Alabiba? It's real simple. To stop Alabiba, you put a sink in place. When it imports into the country, you go to a computer system. When your trademark is registered, you look at what you're dealing with, and if it's not in the system, it can't come into the country. It gets cited, it gets put off to the side until you figure out what it actually is and who it's infringing or who it's for. So, I mean, there's got to be some steps into place. So when I mortgage my house, and I come from absolutely zero, and I mortgage your house because you've invested into my item, I feel I wake up in the morning and I'm passionate. I get out of bed because I want to, because I have passion to build something. So I don't understand how, I respect you for coming here, and I respect you for talking, and I respect a lot of your answers, and I actually concur with a lot of your answers, but there's a lot of answers there that bother me about the reform of of what we need in Washington. I've been out to Washington multiple times, and I had a patent that, demoralized and thrown out instantly. And then my CIP came in, which was a much better patent anyway, and I was able to proceed with my toy. But I think that we should classify patents. I think if it's a consumer goods patent, it should fall into a different sector than maybe a pharmaceutical patent, or maybe a life shelf of a banana patent, which is the technology patent. Because that's basically what Bill Gates has said. It has a shelf life of a banana, and I would concur with that, with the way technology moves. And I'm just asking you, do you see that in the future of patents? Maybe putting them into sections? Because every deal is different.
Yeah, the view that like some patents should have shorter terms is, that's something that, some of the high-tech folks were a little more patent skeptical of pushed in the past. I mean, you're right, yeah, different products have different life cycles, and for those pharma folks, that patent is just as valuable, even more valuable towards the very end as it was in the beginning. And in the tech sector, you could pretty quickly, someone finds a design around it, the life cycle is pretty short. But, well, this is kind of something out of PTO's hands. We have a 20-year term for filing, plus PTA if the agency's a little slow in getting you the patent, and it's the same across all technologies. We've agreed to that unitary system too in a lot of our trade agreements now, because we're afraid of foreign countries, manipulating that against us. In the TRIPS agreement, we, got this agreement, you treat all technologies the same, because we didn't want someone saying, oh, this area where the U.S. is making a lot of money, where they have the valuable technology, impose a shorter patent term there for our national interest. I believe that was the reasoning beyond that, but PTO doesn't have discretion to change the law. It's, once we grant you the, your claims, it's, 20 years from your filing date, plus any PTA or PTE you got, and that's it. We don't, the rules we operate under don't distinguish among technologies.
Do you think they should?
It's kind of above my pay grade, and, I really haven't, gotten into that debate in quite a while. I just know some of the tech people, some of the big high-tech companies, that, Google's of the world, push that idea that, they want shorter patent terms in their field.
But it sounds like, from what you're saying, though, that perhaps this 301 investigation that the current administration is going through might end up handling these issues we're talking about to some degree, right?
Well, the 301 is focused on trade practices in China,
Okay.
in particular. But again, that's such an enormous source of the counterfeiting and infringement we see that obviously just addressing that one country would deal with.
I filled up 2 60-page passports of going to China. They copy everything. And if it's on Kickstarter, it's out before the actual inventor gets a chance to raise funds. That's exactly what happened with a bunch of balloons. My partner, my friend, not my partner, my friend, sold 130 million units before the actual product of a Kickstarter campaign was out.
You're talking about Josh? Come on, Josh.
Yes.
Yeah.
So Telebrands knocked it off. They saw it on Kickstarter. They saw it raise $2 million. They made one phone call to a fast factory in China, and China moves faster than, China runs 24/7, 7 days a week. It does run that way. And so they made a phone call, Telebrands had it on TV, started making incremental revenue, Walmart bought it. Walmart, you gonna sue them? They have 8,000 lawsuits on any given day. What are you gonna sue them? You need them. You're gonna sue, you got eBay, Shopify, Amazon, they're all search engines, that's all they are. And now you bring Alibaba. I made battery-operated shoelaces. I spent $125,000, mortgaged my house to make these things. I brought over 1 container. It took me 18 months to make the item. By the time I brought it over, 22 factories on Alibaba were supplying battery-operated shoelaces. Only cost $3,300 for the mold. And once you know how to do it, which I give you, once you have a sample of mine, you know how to do it. So it's hard to get out of bed and be very happy and gung-ho about making this brand or starting a brand or revolutionizing the world when China's there to duplicate you like that. And with 3D printers, the game is totally changed because it happens very quick.
Is Amazon subject to the 301 investigation? After all, they are a multinational corporation, and they do the same thing as Alibaba.
I'm not a trade expert, but I'm pretty sure the 301 investigations are just country specific.
Okay. So they have almost a country.
Yeah. You know, I mean, we hate seeing this stuff at PTO because, you know, we love it when a good invention gets patented and someone's creating a market, and it just kills us to see a small inventor like, you know, get ripped off like this.
It's true. They did say that when I was at the office. They did. I agree with that.
You know, we just
That doesn't help.
we just hope our our counterparts in other parts of the government you know, do what they can to bring enforcement to bear and to shut this down. Other questions? Anything else, folks? Would yes.
Question to. I've got a question to the question that you asked. First of all, thank you for coming and thank you for your long service in the PTO office. As far as being a fledgling inventor, this is my first year here. I feel like the biggest focus has been on problems with the heat tabs. Now that we have a few years of experience under our belt, like you said, with these next iterations, what would you like to see different in new iterations that we can focus on to help protect our rights?
You mean iteration, like rules within PTAB proceedings?
Correct, yes. So kind
You know,
of, you see ourselves
our
just.
new director is going to be confirmed shortly, and I'm sure he'll have his own ideas about, believe me, there are things I would do differently, et cetera, but I can't get out ahead of the new boss. Really going to need to follow his direction on these things. Yeah, but I'm confident that, again, like, I'd be surprised if we didn't revisit some of these things now that there's been 5 years under our belts, and you know, we have all this data and all these suggestions from you know, the outside world. And we could have maybe started some of this stuff a little earlier too, but I'm pretty confident that you know, the coming years will take a hard look at a lot of these rules and readjust things to make the proceedings, you know, fair and efficient and transparent.
I was threatened with an IPR in Nancy Pelosi's office by one of her staff if I didn't leave the House and go to the Senate. I basically double dog dared him to do it, but I would have been completely helpless had that happened. And there is no financial incentive, so this is the problem with third parties. If they're not a party to litigation, they can file an IPR, all of the costs go on him, or it would have all gone on me. So that's a real big problem.
Yeah, that's one of the issues that's being considered and debated, and I'm sure will be discussed and considered going forward. Yeah, certainly the congressional staffers, which I used to be one, shouldn't be threatening IPRs or anything.
That's exactly what you did.
So I hadn't heard a story like that before.
Well, I've talked to a number of senators, chief of staffs, including senators, and you know, their plate's pretty full with a lot of other things. So this is not front and center for them, but it is for me.
Anyone else? Any other questions? In the back there?
Maybe this was already discussed, but is there anything being currently done to speed up the entire process of patent approval? Because we're mentioning technology, for instance, and we all know that, look at Facebook, it's amazing it's still around, but I mean, MySpace really isn't, and you can't expect technology in general to be relevant in 2 or 3 years when and if and when that particular application is approved.
So we do have accelerated examination, which we charge
30 grand.
Yeah, well, not 30, it's that was about $4 grand. But,
Mine was 2.
if you're a small inventor, if you're a micro entity,
Yes.
then you get a 75% discount. So if you really have something that you just need that patent right away, you can pay that extra fee and file for that. Otherwise, you know, there's, you know, the backlog's obviously been an issue for us for about 10 years. 2 directors back, Dave Kaplis made it a real priority to bring the backlog down, and that was basically done by hiring a lot more examiners. We've gotten a lot of experience in hiring examiners these recent years at PTO. You know, hiring a lot of examiners at once is also kind of a dangerous thing. You want to make sure that the quality of the people you're hiring remains constant. We've kind of just recently at PTO settled on kind of ideal target numbers. So we keep trying to increase the size of the core to bring down the backlog, but we've also kind of learned lessons about trying to hire too many in 1 year, because you end up kind of dipping lower in the quality pool. But we are trying to expand the core, trying to meet those average goals of 10, 20 pendency, 10 months for the first office action, 20 months for, final decision. And we've recently also adjusted those goals towards, at least down to the work group level, trying to meet the PTA limits for every single patent. So not just an average of 10 months, but within a work group, all patents get that first office action within 14 months. The average 10-month pendency is great, but if your art unit is still waiting 20 months to get a decision, then it doesn't do you much good that the average is only 10. So we're trying to readjust our resources, not just to continue to work towards those 10-20 goals, but to also guarantee that everyone, the main goal is, the toughest one to meet is that one on the first office action. And under the patent term adjustment statute, you get extra patent term if the office doesn't issue that first action within 14 months. So we kind of took that as, well, this is a goal Congress prescribed for us. They decided it's unreasonable not to meet that. So let's try to meet that 14-month goal for every patent, and not just have an average of 10 months. So we're working on it, just a long, slow process. And we continue to hire above attrition rates, but again, we don't want to hire too many at one time, because we found that all the universities in the country graduate so many good candidates at a time, and if you hire to a number, you end up decreasing quality, which creates its own headaches, and it doesn't really help the system. But it's a issue we've been focused on for about 10 years now. We continue to work on it. We haven't let our eye off the ball on pendency and getting a prompt early office action.
Does an examiner get a bonus if he gets issued patent? How's he paid, if you don't mind me asking?
I don't know all the details. You can get production bonuses and overtime. Our examiners are unionized, so this isn't just management's discretion that we're going to give you this, this, and that. We are actually prevented, our labor agreements prevent us from giving bonuses at our discretion. It has to be under rules that are worked out with the unions to ensure it's fair for all examiners. But yeah, if the quality of your work is good, so you can't let quality slip. If the quality remains high, and you exceed your targets, then you can get a bonus. And for some examiners, that becomes a pretty good chunk of change. We have some really high performers who are willing to put in that extra time, and if they're really good, examiners generally, then frankly, we want those guys working even harder and putting in that extra time. And it's completely worth it to pay them the extra money, because you don't have the fixed costs. So we love overtime, and PTO is a way to kind of increase our productivity.
And where can you go to get your examiner's history of what he's issued and what he hasn't? It's very important, actually.
Yeah, I know there are certain private websites that track that kind of information in an examiner's history. That's kind of an internal patents organization management issue for us.
But you can see if he's issued 2 in 3 years or 5.
Yeah, we track that kind of stuff because we want to make sure someone's not having a problem.
Correct.
And if there's some unusual pattern of behavior, then we want to take a harder look at, what's this guy doing over there? What's the quality of his work, et cetera.
Can you?
Again, thanks so much for coming here. I appreciate it. It's a brave thing to do. To come out here. And I hope you continue to do it, or other people in a management position at Patent and Trademark Office do that. And I was wondering, is there any particular office or group of people or independent inventors who are having problems that they think you ought to know about, where they can send their comments as opposed to just writing, Patent and Trademark Office or Commissioner of Patent?
We have an office of ombudsman, and what we do track is, you get, every examiner, no matter how good they are, occasionally gets some complaints.
About situations that the other gentleman had brought up.
Yeah.
With PTAB and stuff like that, and suggestions for possible ways of improvement.
So on PTAB in particular, I know our PTAB leadership team, led by the chief judge, is kind of looking at all of these issues and doing a lot of internal analysis. to kind of be ready when the new director comes in to hit the ground running if he wants to go in various directions. So please do, if you have ideas or thoughts, send a letter to David Rushke, the chief judge of the PTAB. I know he reads them all. He's thinking about all these issues. Just to give an example, like one thing we've been studying for a while now at PTO is the amendment process in IPR. Why are there so few amendments in IPR? The statute authorizes amendments, but out of like 4,000 instituted IPR so far, I think there have only been about 118 motions to amend, and all but half a dozen of those have been denied. And one of the conclusions we've come to is we probably, we need to have a more robust amendment process. You need to give people earlier notice of what's going to happen in the case, because right now, throughout an IPR, almost all IPRs are accompanied by co-pending district court litigation, and in that IPR, people are really focused on that district court litigation, and they don't want to amend, because if you amend and it's deemed substantial, then you lose all your past damages. And so it's really hard to get someone to think hard about an amendment while they're still trying to defend those original claims. You're sort of asking people to say, yeah, I didn't kill him, and if I did, I had diminished capacity. That's my amendment. What we would probably need to do is have some kind of structure where people get earlier notice that the original claims are going to be deemed unpatentable, and then give people an opportunity to think hard about what kind of, whether you have an invention in there that's still salvageable, that's still patentable. And I've asked senior leaders on the board, do you feel like you see a substantial number of cases where you think you as the judge think the original claims aren't patentable, but you do think there is a patentable invention within there, and they've said that they do. And why aren't people capturing that? Some of it may be just people, they can't keep their original claims, they just don't care. It's late in the life of the patent, and it's really about those damages in the district court litigation. But some of it may be also the way the proceedings are structured. And again, the AIA has this built-in feature of we have pretty broad authority to restructure these proceedings. And amendments in particular, I remember the discussion about amendments in AIA trials, and the Patent Office really didn't know how it was going to handle amendments in this new type of proceeding that's not examinational. It's like district court, but you don't have amendments in district court, so how's it going to work here? So they asked for this broad grant of authority, and I was a staffer at the time, Congress gave them this pretty broad authority to set standards and procedures for amendments. So now I'm at the PTO, we have the power to tweak and modify this amendment process so that it's more useful to people. So people, even if their original claims go too far, if they're obvious and prior art, they can still capture an invention inside of those claims, something that's still salvageable. And again, the judges themselves have told me they see a substantial number of those cases, so there's definitely more potential for amendments that capture a patentable invention.
If there's no other questions, I'd like to thank you very much for attending, coming down to Tampa. I really appreciate it.